As you guys can see by the title, it looks like UMG is clapping back at Drake, and they're not having any of this. It's clear they don't want to get into the discovery phase of this lawsuit Drake has against UMG, obviously because of the things that might reveal. So they're trying to end this now. So Drake recently filed a lawsuit against UMG saying that they used some questionable and possibly illegal tactics to promote Not Like Us. Again, this isn't about Kendrick Lamar. This isn't about the beef. Y'all want to make it about the beef? That's fine. Drake made it very clear in his filings that this is not against Kendrick Lamar. This is against UMG using certain tactics and using their power and their influence with iHeartMedia, with Spotify, to not only push Kendrick to defeat Drake, but to diminish Drake's brand and his value so they can get a discount deal on Drake's re-signing that is coming up here very soon. Now, Drake came out, he filed a lawsuit, said, UMG, you can't do this. It's not fair. You need to pay me what I'm worth. At the end of the day, I think Drake was lame for filing this lawsuit. The reason being, he has benefited from this process his entire career. What measure he benefited from, I'll let y'all have that discussion. But I think if you're going to play the game, you got to play the game, Drake. You can't go out here and get mad at UMG for using the system that you benefited from against you. So with that being said, I also, on the other hand, think Drake has a great case here because the tactics that are used by UMG, we know historically, I know historically from being in the music industry, they're illegal and they're unethical. All right, let's just be real. UMG has a huge investment in Spotify, the world's biggest music streaming platform. They have huge influence there. They make certain deals with Spotify to push certain artists to do certain things. You know, can get into the botting conversation if you want to. Same thing with iHeartMedia. Same thing with a lot of these other platforms. So when it comes to the legal aspect of things, yes, I think Drake has a case here. And that's how we're going to look at it moving forward. So now recently Drake came out and he gave some more information and background and said, hey, UMG, y'all are wrong for this. I don't like this. This isn't fair. And I want to move forward. Not only do I want to move forward, but I want to get pretrial discovery. I want to make sure that I have everything that I need to prove my case. And UMG said, no, we don't want to do that. Because we don't want you talking to Spotify. Spotify's like, hey, UMG, sorry, I'm out of this. They call Drake up. Spotify says, Drake, what do we need to do to get out of this? Drake says XYZ. Spotify says, all right, we're gone. They're gone. iHeartMedia, same thing. They say, hey, Drake, we're not doing this. We're not trying to do what UMG's doing. Your fight's with them. Drake says, all right, cool. They call him up. They come up with the deal. X, Y, and Z. iHeartMedia is out of there. So now it is officially Drake versus UMG. And UMG is getting sick of it. They're moving to dismiss this claim entirely. And they don't even want to get to the discovery part of this. So what do they say? Shout out to Document Ting, says UMG's attorney filed a motion to dispute Drake's lawsuit. Drake's claims were called meritless and how public embarrassment from his beef with Kendrick Lamar is the real reason he chose to sue. Oh my gosh. That's not the case. That's not the case. And we're going to get into it here. Shout out to Document Tings for this. We're going to get into the full memorandum here. We're going to read the first few pages of this, but I want to first get into this motion from UMG. What do they say? They just filed this yesterday, and this is a notice of motion and motion to dismiss. Oral arguments requested. UMG, what do they say? Please take note that pursuant to Federal Rule of Civil Procedure 12B6, and upon the accompanying memorandum of law, request for justice notice and declaration of rolling a ransom, defendant UMG Recordings Incorporated respectfully moves that this court before the Honorable Jeanette A. Vargas at the United States Courthouse of the Southern District of New York, located at 500 Pearl Street, New York, New York, for an order dismissing the complaint for failure to state the claim. They're basically saying this thing is BS. Come on, Judge, get this out of here. So now we're going to hear more information from UMG on why they think the judge should go down this route and dismiss this claim entirely. Let's go ahead and get into it and see what they say. UMG Recording Incorporated memorandum of law in support of its motion to dismiss. So we're going to go all the way down here to the introduction, and it gets spicy right at the beginning. What do they say? Yeah, I want it all. That's why I strive for it. Diss me, you'll never hear a reply for it. Drake on Successful. Oh, man. We're getting into it already. The plaintiff, one of the most successful recording artists of all time, lost a rap battle that he provoked and in which he willingly participated. Instead of accepting the loss like an unbothered rap artist he often claims to be, he has sued his own record label in a misguided attempt to salve his wounds. The plaintiff's complaint is utterly without merit and should be dismissed with prejudice. Oh, man. Shots fired already. What does UMG have to say about Drake? In the spring of 2024, two of the most popular recording artists in the world, Kendrick Lamar and Aubrey Drake, engaged in a high-profile rap battle. Over the course of approximately 2 months, they exchanged increasingly vitriolic, never seen that word before. I know vitriol, but vitriolic, good Lord, and incendiary diss tracks, in quotations, sometimes responding within hours of each other. Drake encouraged the feud. For example, when he felt that Lamar was taking too long to respond, Drake released a second recording where he said, drop, 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 drop. Y'all remember that? In which he goaded Kendrick Lamar to continue the public rap battle. He did. That was on Family Matters, right? I believe it was on Family Matters. Lamar did just that. And collectively, Drake and Lamar released a total of 9 tracks taking aim at each other, which is one of the great rap back and forth rap beefs of our generation. Let's be real. Multiple commentators declared Lamar to be the winner of the battle. I was one of those. Not Like Us, the track in the feud, or the arguable track in the feud, is the subject of the complaint. The recording and the music video were released by Lamar through defendant UMG on May 4th of last year. Not Like Us was a massive commercial and artistic success. The record was the best-selling rap recording of 2024 and won the Grammy for Record of the Year, and the accompanying music video won the Grammy Award for the Best Music Video. The song Not Like Us won the Grammy Award for Song of the Year and became an ambiguous cultural phenomenon, among other things. Lamar performed the song at the 2025 Super Bowl halftime show to a record audience, and Saturday Night Live parodied it in the recent 50th anniversary special. Not Like Us, like all recordings in the feud between Drake and Lamar, and like many notorious diss tracks throughout rap's history, consists of a series of hyperbolic insults. Okay. UMG, this is not the issue. So again, I don't know why they're starting this memorandum like this, because Drake made it clear. I don't care about Not Like Us. It's not about Not Like Us. Not Like Us was the tool. Not Like Us was the tool that UMG used to go after Drake. So that's why this song is being mentioned. It's not because of the songs. They're basically almost making Drake's point here by saying how successful the song was. It's like, yeah, the song was successful because you guys continued to push it and went out of your way to make sure that it's successful. And that's what Drake's point is. It's not about the song itself. In the lawsuit, again, we're not talking about Drake's feelings overall. We're talking about in the lawsuit, in Drake's initial lawsuit. The point is, UMG used Not Like Us, and they pushed it, and they pushed it, and they pushed it, and they pushed it. And now we are where we are. So we're going to keep going. We'll get into it, y'all. Hold on. So Drake has been pleased to use UMG's platform to promote tracks leveling similarly incendiary attacks at Lamar, including most significantly that Lamar engaged in domestic assault and that one of Lamar's business partners and managers is the true father of Lamar's son. They make a good point there. And this is what I said at the beginning. Drake has been using and benefiting from this platform. So now you want to bite the hand that feeds you, in a sense. It's a fair point by UMG. But now, after losing the rap battle, Drake claims that Not Like Us is defamatory. It is not. While the complaint focuses almost entirely on Not Like Us, it disregards the other Drake and Kendrick Lamar diss tracks that surround it. Not Like Us, as well as the conventions on the diss track genre, and thus critically ignores the context of the dispute. I think that could be argued. Assessed in context, as it might be, Not Like Us clearly conveys non-actionable opinion and rhetorical hyperbole. Diss tracks are a popular and celebrated art form centered around outrageous insults, and they would be severely chilled if Drake's suit were permitted to proceed. Drake also alleges that Not Like Us constitutes second-degree harassment, but sues under a criminal statute that does not prescribe speech and has no private right of action. Finally, Drake's claim that UMG's promotion of Not Like Us, here's where I have an issue, violates the New York General Business Law 349, but fails to allege any of the elements for that claim. Well, we'll have to look at that law, because I think Drake talked about payola in this lawsuit. He talked about certain practices of discounting a royalty payment or discounting a licensing percentage to Spotify to push a certain song. But again, that's the system. Can you really complain about it? I don't know. Notably, less than 3 years ago, Drake himself signed a public petition criticizing the trend of prosecutors using artists' creative expression against them by treating rap lyrics as literal fact. See UMG's request for judicial notice. And then Drake recognized, when it comes to rap, the final work is a product of the artist's vision and imagination. Drake was right then and is wrong now. Dang, UMG! The complaint's unjustified claims against UMG are no more than Drake's attempt to save face for his unsuccessful rap battle with Kendrick Lamar. My gosh. The court should grant UMG's motion to dismiss the complaint with prejudice. They say Drake is in his feelings, pun intended. Hey man, UMG is a little savage on this one. They said Drake had his feelings hurt. I think they're intentionally missing the point. The point being, Kendrick Lamar said certain things in Not Like Us that could hurt Drake. UMG then went out of their way to push this and to spin it to benefit them when it comes to negotiating their deal with Drake. Again, you want to say the defamation doesn't count, I might give you that one. But UMG, y'all do have some explaining to do when it comes to how you're promoting and pushing music. And I think that's one of the reasons there's so much pushback here. Because if not, they would let's just keep moving forward, right? That's not the case here. All right, what's their argument? We've got the legal standard here. To survive a motion to dismiss under Rule 12b-6, a complaint must plead enough facts to state a claim to relief that is plausible on its face. The court can credit only well-pleaded factual allegations and must disregard legal conclusions. In certain circumstances, the court may permissibly consider documents other than the complaint in ruling on a motion under Rule 12b-6. All right, such as documents incorporated into the complaint by reference and matters of which a court may take judicial notice. All right, so let's keep scrolling down and see what happened. Drake fails to state a claim for defamation. Y'all let me know if you agree. Drake, who had no concerns using UMG's platform to publish slurs about Kendrick Lamar during their rap feud, now claims that Not Like Us is defamatory. These allegations, which are directly aimed at chilling legitimate artistic expression, safeguarded by the First Amendment and the New York law, they say they're meritless. Here's the thing about this, though. If Kendrick Lamar has a problem with it, he can file a lawsuit, right? And if that happens, then I'm sure Drake would go down the path he has to go and see that through. One, I don't think Kendrick Lamar is going to do that. And two, that's not Drake's point. Drake's point is UMG used Not Like Us. It's not that Not Like Us it has, it's the fact that it exists. It's the fact that UMG is like, hey, let's keep pushing this and let's encourage people to think Drake is guilty of certain things that he's not. And that's where he had the problem. UMG wasn't pushing the other songs. And I think that's where we're going to have an issue with this argument. Not like they push Not Like Us, obviously. Drake fails to state a claim for the defamation because Not Like Us conveys non-actionable opinions and rhetorical hyperbole, not fact, and because Drake cannot adequately allege that UMG acted with actual malice. That's going to be tough to prove. To succeed on his defamation claim, Drake must establish a defamatory statement and concerning the plaintiff, publication to a third party, falsity of the I'm gonna get there. Falsity of the defamatory statement and special damages or per se accountability. And then they cite this case here. Were, as here, the plaintiff is a public figure, he must prove that the alleged defamatory statement was made with actual malice. That is, made with knowledge of its falsity or with reckless disregard of whatever it was false. Okay. But the problem is Drake's not. This is why it's going to get weird. Because again, Drake made it clear he's not going against Not Like Us. He's not going against the company that created the gun. He's going against UMG for using the gun. The gun here is Not Like Us. And UMG, it pointed it at Drake and they said, let me get that discount on the next deal. So this is going to get interesting. And I want to hear their arguments on this because did Kendrick Lamar make these false statements with malice or with reckless disregard of whatever is false? Obviously, because UMG, by their own admission, that's the nature of diss tracks and diss track culture. But does Drake have to prove that, or does he have to prove that UMG used this to defame him? So it's like secondhand defamation almost. Boy, this is going to be weird. Because again, he's not going against Not Like Us. He's going against UMG's use of the song. Boy, this is interesting. The alleged defamatory material is non-actionable opinion and rhetorical hyperbole. To be defamatory, a publication must convey fact, not opinion or rhetorical hyperbole. No. Because if that's the case, A$AP Rocky wouldn't have a lawsuit either. Expressions of opinion, as opposed to assertions of fact, are deemed privileged and, no matter how offensive, cannot be the subject of an action for defamation. Whether a statement is fact or opinion is a question of law for the court. To distinguish assertions of fact from non-actionable opinion, New York courts analyze that whether the specific language is issue has a precise meaning, which is readily understood, whether the statements are capable of being proven true or false, and whether either the full context of the communication in which the statement appears or the broader context and surrounding circumstances are such as to signal readers or listeners that what is being read or heard is likely to be opinion, not fact. Interesting. How would you interpret the music? We're bringing music back into it again, I think. At its crux, the question for the court to resolve as a matter of law is what a reasonable person hearing or reading the statement would take it to mean. I mean, I think most people are saying that Drake is a PDF. And they're out here saying, yeah, I think Drake's a PDF. He did it. Just look at what he's doing. Oh, he took a picture with that young person. I think he did it. I don't know. Are they going to use that as evidence moving forward? Some YouTube videos might be brought up in this lawsuit. In this assessment, context is key. The Court of Appeals of New York has consistently focused its analysis on the overall context in which the complaint of assertions were made. This includes both the immediate context in which the dispute would appear, as well as the larger context in which the statements were published, including the nature of the particular forum. And then a statement's tone and apparent purpose may signal that it is not conveying an accurate factual assessment offered by a disinterested observer. You know what? I think we need to bring back Detective Super Investigator Viverito for this, because we need a diss track expert, and I think she could probably qualify for that. So we'll have to do some research and see if that's in her field of expertise, because we're going to need a diss track expert to really analyze the tone and apparent purpose of this track. Was it to obliterate and destroy? Do we go back to some of the other Kendrick Lamar diss tracks to where he says, "Don't tell any lies about me, and I won't tell any truths about you"? Oh. I mean, we really need to get a diss track expert on this. This is going to be a tough one. For example, tone may indicate non-actionable opinion where it reflects a degree of anger and resentment, where the tenor is rambling, heated, or speculative, or often escalates into hyperbolic, or where a statement invokes parody, loose, or figurative language. Likewise, the broader context informs whether a statement is reasonably understood to convey factual assertions. Even apparent statements to the fact may assume the character of the statement opinion. When made in public debate, heated labor dispute, or circumstances in which an audience may anticipate the use of epithets, fierce, fiery rhetoric, or hyperbole. Okay, so this may apply here. It seems like it would apply to diss tracks. Let's keep moving. Let's see here. Consistent with that observation, New York courts routinely hold that tone and context render allegedly defamatory publications non-actionable. So it might not apply here. I think that's up for interpretation. The recent case of Rappaport versus Barstool Sports is particularly instructive. There, actor Michael Rappaport alleged that statements by Barstool Sports accusing him of having an STI and assaulting his ex-girlfriend, including several statements in a 6-minute diss track in which defendants assaulted a constant stream. Rapped a constant stream of insults and slurs about Rappaport against a backdrop of unflattering video clips and images were defamatory. So he lost that one. Interesting. The district court judge rejected the claim as a matter of law. The statements were largely laden with epithets, vulgaries, hyperbole, and non-literal language and imagery, delivered in the midst of a public and very acrimonious dispute between the Barstool defendants and Rappaport that would have been obvious to even the most casual observer, and published on social media, blogs, and sports talk radio, which are all platforms where audiences reasonably anticipate hearing opinionated statements. So they're saying nobody would basically look at this and believe that Drake's a PDF. Nobody would look at this and believe that Kendrick Lamar put his hands on Whitney. Nobody would look at this and think such and such. So with that being said, I have to keep saying it. That's not the main issue. The main issue is their promotion and their constant pushing of the track. It's going to be a tough battle for Drake, I think, on this one. But I think he still has a case here. It'll be interesting to see how this is interpreted by the judge and if the judge thinks it applies here. Because in this case, it was Barstool Sports versus Michael Rappaport, right? Now, in this instance, we have a third party. Drake is saying, leave Kendrick Lamar out of it. UMG, you're the problem. You're the issue. I don't know. The Second Circuit affirmed in Rap Report in 2024, holding that the district court appropriately considered that the statements at issue were made in the context of a hostile, vulgar, and hyperbolic feud, in which the use of vulgaries and hyperbole function as a strong indicator to the reasonable reader that the statement is not expressing or implying any facts. Again, I mentioned Kendrick Lamar's quote about don't tell any lies about me and I won't tell any truths about you. I can guarantee y'all that if this goes forward, that's going to be brought up by Drake's camp. Because in that instance, is him saying, don't tell lies about me and I won't tell truths about you, is that hyperbole? Or can that be taken as true? And then moving forward after that point, everything that Kendrick Lamar said after that is supposed to be taken as facts? Looking first to its tone, the 4.5 minute rap diss track consists of a series of fiery rhetoric and hyperbole. And not surprisingly, given the context, the record reflects a considerable degree of anger and resentment. And exaggerated vitriolic words pervade the recording to attack all aspects of Drake's life, including his career, authenticity, brand, relationships, and character. Exaggerated imagery in the music video enforces that Not Like Us is not intended to reflect a factual analysis. For example, the video opens with Kendrick Lamar whispering to a song that he sees dead people, a nod to the film The Sixth Sense, implying hyperbolically that Drake has been defeated in a rap battle. The video also shows Lamar beating an owl piñata with a disclaimer, no OV hoes were during the making of this video. Oh, man. And staring down the owl in the cage. This imagery enforces the non-factual nature of Not Like Us. Indeed, no reasonable listener would require a disclaimer that the piñata is not literally Drake and his crew. The imagery is satirical and vitriolic, all of which signals to the audience that the video does not convey sober factual analysis. I think the issue from that is Drake's house was shot up. People broke into his house after this. So they're going to have a problem there. Again, I still think Drake has a case. And Not Like Us isn't really the issue. But I get what they're saying. Likewise, the album's image of Drake's Toronto house, which is probably going to be a problem, is obviously doctored, further underscoring the non-factual nature of Not Like Us. Again, no reasonable viewer would believe that the image of Drake's Toronto mansion with 13 offender markers is real. I don't know about that one. The image is hyperbolic and exaggerated, conveying opinion, not fact. Dang. The broader context also reinforces that Not Like Us is non-actionable. Not Like Us did not emerge out of thin air. It was Lamar's culminating diss track in one of the nastiest lyrical warfare rap feuds in recent history. It followed the release of 7 preceding tracks in which Drake and Lamar hurled increasingly vitriolic allegations at each other, including Drake's slurs that Lamar's son was fathered by someone else, Dave Freeze, and that Lamar cheats on and physically abuses his fiance. Oh, man. If ever there was circumstance for the evidence to anticipate the use of epithets, fiery rhetoric, and hyperbole, this is it. Moreover, assessments of the broader context makes clear that Not Like Us relates to well-known controversies that Drake himself acknowledged and perpetuated. They might have a point there. And facts and criticism concerning Drake's relationship with minors predate Not Like Us and have been widely reported. Oh, dang. Come on, UMG. Y'all gave this man almost $500 million. Don't do that. They didn't say criticism. They didn't say rumors. They didn't say, oh, well, the grapevine says. They said facts and criticism concerning Drake's relationship with minors predate Not Like Us and have been widely reported. Oh, man. Why'd y'all say it like that, UMG? That's kind of dirty. Noting that Lamar is indicating Drake for the years of rumors and speculations around his misbehavior around minors, and that Millie Bobby Brown, here we go, is one of the things that most people are aware of when it comes to Drake and the rumors around him. She talked about texting with Drake when she was, a minor. Notably, Drake himself called on Lamar to invoke the allegations in Tailor Made Freestyle, released before Not Like Us, in which he said he had Tupac's AI-generated voice rap that Lamar should talk about Drake liking young girls. In the Heart Part 6, which was absolute trash, Drake, I'm sorry. Drake also affirmed that he understood Lamar's statements in Not Like Us to refer to the Millie Bobby Brown controversy, stating, "This Epstein angle was the ish I expected, and only FM Whitney's, not Millie Bobby Brown's. I never looked twice at no teenager." Clearly, Drake, that was the weakest. The Heart Part 6 was terrible. Clearly, Drake himself understands that Lamar's lyrics refer solely to well-known issues. Taken together with the fact that Not Like Us was released in the context of a combative, vitriolic rap diss battle, it would be obvious to even the most casual observer that Not Like Us is not an accurate, factual assessment offered by a disinterested observer. In sum, the tone and broader context in which Not Like Us was released makes plain that the recording, video, and album cover convey rhetorical hyperbole and opinion not based on anything beyond controversies that have been widely acknowledged, including Drake himself. Drake fails to state an actionable claim for defamation. Also, Drake cannot allege that UMG acted with actual malice. This is going to be interesting. Drake's defamation claim fails for the independent reason that, as a matter of law, he cannot allege that UMG acted with actual malice. A public figure can only prevail on a defamation claim where clear and convincing evidence proves that a false and defamatory statement was published with actual malice. That is, with deliberate or reckless falsification. The element of actual malice in a defamation claim focuses primarily on what a defendant knew or believed at the time a purportedly false statement was made. Interesting. And of course, UMG is going to defend themselves here, and they're going to say, to survive a motion to dismiss, a defamation plaintiff must allege specific facts that plausibly evidence actual malice in a clear and convincing manner. Courts recognize that in certain circumstances, such as works of fiction, parody, and satire, the actual malice inquiry must focus on what the publisher subjectively intended to convey. For example, well, I think that's what Drake wants some of this discovery for, but we'll hear their response at some point. For example, where the speaker intends his statements as outrageous parodies or caricatures, there may be no consciousness that the speaker is publishing something false because the speaker does not think he is publishing a statement of fact, and therefore lacks subjective knowledge of recklessness as to the falsification of a statement of fact required to show actual malice. So what's your defense here, UMG? So to here, there is no basis for a claim that any person at UMG had the subjective intent to publish false factual statement about Drake. UMG released a rap diss track conveying fiery rhetoric and insults, not factual assessments, much less false ones. UMG engaged in the same conduct when it distributed Drake's Family Matters, in which Drake rapped that Lamar engages in domestic abuse, is not the father of his son, Much like parody and satire, hyperbole, exaggeration, and insults are endemic in rap, particularly in diss tracks. Rappers know that their lyrics are exaggerated and non-factual. That is part of the craft. So are they going to have to get a statement from Kendrick Lamar saying that, or are they just basing it on previous case law? That's what it sounds like here, but I can't imagine Kendrick would come out and say, he's not really a PDF. I was just kidding, guys. I don't think so. And Mo is saying, I didn't hear rumors until that song. Well, you need to call over the OVO headquarters and let them know that, and they might use you as a witness. Rappers know that their lyrics are exaggerated and non-factual. That is a part of the craft. The actual malice question is therefore what UMG intended to convey. And Drake has not alleged any specific facts plausibly evidencing in clear and convincing manner that anyone at UMG intended to convey or indeed believe that the public would understand Not Like Us as conveying anything other than what it was, an incendiary diss track. UMG, no. And again, this is where I think the YouTube videos are going to come out. You're going to see a lot of content creators. Yeah, this is going to be a tough one. You're going to see a lot of content creators that were mentioned before reviewing the videos. And if they were allegedly paid and asked to do these reviews, then that's going to be a problem. Especially if they sit there and point out and say, oh, this is actually where he's talking about this. Oh, he might actually be talking about Millie Bobby Brown. What does he mean by that? So it might be an intention there. We'll have to wait and see what they say. And we're not going to get into the harassment here. I'm going to leave it there for now. I'll be posting this full document over on the Patreon, so y'all can go check it out there. And I might even break this down a little bit further over on the Patreon as well. But let me know what y'all think about this in the comments and in the chat. Does Drake still have a case here? Is this a decent response from UMG? And would a judge rule in their favor? And what do you think Drake is going to say in response to this? I guess we'll have to wait and see.